Okay, so it's seems like it's working.
Seems like it, yeah.
Just gonna wait for the YouTube channel to load. Okay, yeah. So I think we are good to start whenever.
Sounds good. We've got 62 attendees waiting in the room. So whenever you're ready, feel free to press start webinar. And I will be here on mute in case you need anything technical. Feel free to chat me on the side and we'll be good to go.
Great, thank you so much.
Not a problem. Have a great event.
Lina and Cory, are you ready to start?
Yep.
Awesome. All right.
Meeting is being recorded. Good afternoon. Welcome, everybody. It's so great to have you all here at our first public event for the Center for Law and the Economy. This is a center that we launched a few months ago, and a core part of it is helping grow and develop a student network. One of the best parts of my job at the FTC was getting to visit various universities and campuses. And time again, I was just floored by how much interest there was among young people and students in doing the type of work that we were doing at the FTC. The Federal Trade Commission was more focused on consumer protection and antitrust, but it seemed like more generally there was a surge of interest in figuring out how it was that so many pockets of our economy seem so screwed up and what lawyers and others across society can do to fix it. And so we're going to be, growing the center, and a core part of it is going to be making sure that students that have this interest are able to plug in. We're going to be doing a whole bunch of programming, including with, policymakers, folks at the federal, state, and local level, key experts and thinkers across various sectors, and then are also going to be, promoting engagement on the scholarly front. And so we'll be rolling out soon some public awards that folks can apply to, so that anybody that's interested in doing more of this work has a place to plug in and really engage. I'm so thrilled that today, for our first virtual event, we have with us Cory Doctorow. Cory is, to my mind, just one of the most astute observers of our economy today. He has a long history in the open internet movement and has been a core advocate for pushing back against centralization and control over the commons. Most recently, he has become famous for coining the term "inshitification." He also wrote a fantastic book by that same title, which I highly recommend. And more generally, just really has been capturing so astutely what the lived experience is of an economy that, in corner after corner, is dominated by extreme concentration and extreme consolidation of economic power. So it's a real honor to have him with us today, and so grateful to him for being down for this conversation.
Well, thank you, Lina. It's the honor is very mutual. I'm just such an ardent admirer of your work. I've told you this so many times, but it was a wonderful 4 years and somewhat disorienting to wake up every morning and look at my phone and go, "Oh my God, the government is great." It's not my experience of 25 years of doing tech policy work. Quite the opposite. So, as you say, I've been at this for a long time. I work for a nonprofit called the Electronic Frontier Foundation that has its origins in impact litigation. So, for those of you who are law students, that's the kind of work you can do, but has branched out into other kinds of work and really has multiple pillars now. We have a large technology practice. Those of you who are engineers can look into our projects like CertBot and Privacy Badger, and also a big activist practice. And that's where I fit in. I was one of the first activists at EFF, and that's the work I've done for 25 years. And I was asked to say a few words, and I've been thinking about what I was going to say. And I realized that there's a kind of pervasive story about what people like me were up to in the 90s. And it goes like this, that like we looked at the computers, got way too excited, and thought all we need to do is plug everyone into these things and everything's going to be great. And there's just nothing we need to worry about. And that's just like in no way true. No one gets involved with the Electronic Frontier Foundation because they think everything is automatically going to be great. To get involved in this cause, you have to, on the one hand, really be excited, genuinely, legitimately excited, about the liberatory potential of computers and networks and the worlds that they open up for people. My case is with many technologists. I got myself a computer and a modem, and the world just expanded beyond anything I thought was possible. The circumstances of my birth and the programs that were available to me educationally and the careers that people thought I might be streamed into, none of them were the ones that I had to concern myself with. I found myself in this much wider world. So you have to, on the one hand, be just like, this could be amazing, but also you have to be alert to the possibilities for control and surveillance and manipulation. My other life, I'm a cyberpunk writer. The message of cyberpunk is not it's all going to be great, right? William Gibson is at great pains to tell people cyberpunk was a warning and not a suggestion. And so I think if there's a thing we missed, it's antitrust. It wasn't that we thought technology would automatically be great. It's that we thought antitrust would keep technology honest. And there's kind of a reason for that. My first modem arrives sort of a year after AT&T gets broken up. And the reason is that AT&T's major project was stopping people from owning modems. And the reason for that is if everyone's got a modem, then I can provide a service to you and AT&T can't take money out of it. When they rolled out caller ID, it was $6.99 a month. $6.99 a month to find out who was calling you before you picked up the phone. Or you can't do that with the internet, right? Like imagine if your email had an upsell where it was $6.99 a month to see the to line in your email before you double click the message and saw who it was from. You just switch email providers. And so, the world expanded because they broke up AT&T. And then everyone I knew had an IBM PC clone. And the reason everyone had an IBM PC clone is that the DOJ dragged IBM down the gravel road tied by its ankles for 12 years. 12 years in antitrust hell with IBM. They called it antitrust's Vietnam. And while IBM did wriggle off the hook, after 12 years of this, they were so scarred by like having everything they'd ever said and done exposed to public scrutiny and shown up in court, that they changed their conduct. And so when they made a PC, they were like, well, we know the DOJ hates it when we vertically integrate our parts supply, so we're going to make it out of commodity components. Also, we know the DOJ hates it when we provide our own operating systems and tether operating systems to hardware. So we're going to get this company called Micro-Soft that was founded by like the fail son of one of our board members' friends to provide our operating system. And then when some hackers cloned the IBM PC ROM for Phoenix Computing, they were like, oh, we better not clobber those guys. That's going to look like anti-competitive behavior to the DOJ. And so the next thing you know, IBM PCs everywhere, cheap, weird, interesting. They did stuff no one ever thought they could do. So, again, antitrust to the rescue. And then, Microsoft turns into IBM and they crush Netscape. And what happens? The FTC rides in and they convict Microsoft of antitrust violations. And although G.W. Bush lets them off the hook when he gets elected, they also change their conduct. And so when Google comes along, they don't crush Google the way they crush Netscape. And so at the time, it felt very natural to think that like tech had this dynamism that came from the combination of the fact that you could always make a new technology that plugged into the old one and made it do things the original manufacturer didn't want it to do and expand its capabilities, and that the government would step in and stop monopolization. And we were wrong about the second part. We didn't really understand that antitrust had been shot in the guts and it was like bleeding out its last. And that sort of the last thing it did with the last twitch of its dying hand was shoot at Microsoft and make them leave Google alone. And so then the internet turned into 5 giant websites filled with screenshots of text from the other 4. And it wasn't because of like sunspots or the iron laws of economics or the great forces of history. It was because we changed our policies. We decided to permit conduct that was illegal. And then we got the internet that we have now. And it's not a good one. And so this is what's made me so excited to see Lina and the rest of the new antitrust movement kind of ride in on the scene, because it seems to me like that is revitalizing the thing that we used to have. And, I'm going to tell you, I don't think competition is a good unto itself. Like, I don't want more competition in ad tech. Like, I don't think ad tech should get more efficient. I think ad tech should be extinguished. I think we should stop surveillance advertising. I don't want a competition to see who can be the best at invading my human rights. I like competition because it makes companies into a rabble. Because when there's 100 companies in a sector, they can't agree on anything, much less what their lobbying posture is going to be. They're not dividing up the market like the Pope dividing up the new world, like Google giving Apple $20 billion a year not to make a search engine, right? They are like competing with each other, eroding one another's margins. And when one of them tells a lie to a regulator, someone else checks them on their nonsense. And that's what I like about competition. Not because competition's an intrinsic good, but because it makes them weak enough to regulate. And I'll finish by saying a thing that I tell all my libertarian friends, which is that even if you think the only role for the government is to make businesses honor their contracts, you still have to have a government that's big enough to force businesses to do it. Right? The referee has to be able to boss around the players, or they'll cheat. So the largest corporation you're willing to tolerate determines the size of the smallest government you can have. I don't think there's any intrinsic good to government being big rather. I think government should be as big as it needs to be and no bigger. And honestly, when we have companies the size of Google or Facebook or Oracle, if we're going to have any hope of holding it to democratic account, we need a public state that is going to be large and unwieldy. I'd much rather have smaller firms and a weaker state, because I have lived through moments of the state abusing its power. We're living through one of those right now. I'd rather have smaller forces in the world broadly, because I think that means that you and I as individuals, when we see things that are wrong in the world or just things that could be fixed in the world, we're much less likely to encounter an immovable force that gets in our way. So, Lina, they asked me to ask you some questions. I don't know if you wanted to respond to that. I do have some questions for you. You tell me.
Yeah, I mean, there's so much there. I'll just say, for folks in the audience, Cory and I are going to have a back and forth for a little bit, but really a main goal here is for students to get to engage. So I understand there's a Q&A feature, and so folks should feel free to start using the questions function to start putting in questions, and then we'll shift to that. I mean, Cory, what you laid out is so rich, and I think a couple of things really stand out there. One is the fact that the antitrust and anti-monopoly tradition actually goes all the way back to the American Revolution. And there was a core understanding at that point, and the revolution itself was, a protest against monopoly and the monopoly that the British East India Company had over tea. And, even before the Sherman Antitrust Act was passed in the 1890s, there were a whole bunch of states that actually had core anti-monopoly provisions, even in their constitution. And more generally, there was a recognition that if what we care about at the end of the day is securing real freedom and real liberty for people, you needed to do that both through checks and governments in our government, checks and balances in our government, preventing centralization and the ability of government to exercise arbitrary power in our public sphere, but that we also needed parallel principles in our private sphere, in our commercial sphere, because, as the sponsors of the Antitrust Act said, if we won't accept a monarch, we also shouldn't accept an autocrat of trade. And there was a real understanding of how securing freedom and liberty in our commercial sphere was absolutely essential, because if you allow extreme concentrations of power, practically those entities can bully and coerce and abuse their power in ways that can be, just as harmful to people's day-to-day lives. And so I think those ideas are very closely fused. I think honestly, right now, what we're seeing, with this administration is also a clear example of how state power and extreme concentrations of private power can fuse together, really turbocharge in harmful ways. Louis Brandeis famously was, both an ardent anti-monopoly believer, but also a real skeptic of an overly powerful government. And so these ideas really go together quite deeply.
Yeah, thank you. I think those are points that are very well made. So I have a few questions for you. We're getting some good ones in the chat, but I'm gonna ask you one or two, and then we can move on to these good chat questions. So one of the things I really admired about the work you did and that your colleagues did in the Biden admin, whether that was Cantor or Chopra at the CFPB, but also that stonkingly good memo that Tim Wu wrote for Biden. And I should say for the audience that Tim Wu and I have known each other since we were 9 years old. That like all the best Americans, we're Canadian, and we went to the same weird alternative school in Toronto and lost touch for 20 years, and then sort of reconnected when it turned out we were doing the same work in some, by some bizarre coincidence. And so I admired your incredible tactical nous. I often likened you to the photocopier repair people in the punchline of the famous joke, where someone hires a photocopier repair person who comes in and kicks the photocopier and charges them $75. And they say, $75 to kick the photocopier? And they say, no, I kicked the photocopier for $5. I charge $70 for knowing where to kick the photocopier. And so whether that was you reviving the Robertson-Patman Act or Section 5 of the FTC Act, or the stuff we saw in Tim's memo where he's, finding 19th century railroad acts and saying, by the way, Pete Buttigieg has the power to do this. And, that was very exciting. It was really interesting to see that photocopier kicking going on. And I wondered if you had, you're good at this kind of tactics, if you had any of these leveraged interventions where you stick a crowbar in this crack in the system and wiggle it around and justice comes rushing out. And if you had any like on your wish list where if you get the chance you'd embark on it.
Yeah, I mean, it's such a good question, and I think goes back to this core issue of how there has been in many ways a great forgetting, I think, across the federal government. And I was often stunned while in government at not just the unused powers that sat at the FTC and the FTC Act, but how oftentimes across government agencies there seemed to be a reservoir of tools and authorities that just hadn't been used in some time. And, talking to those other agencies or our staff talking to the general counsel, there would be oftentimes a real reluctance to use those tools, oftentimes out of a, understandable skittishness around, legal risk and litigation risk. And we're living at a moment where there is just, so much concentrated wealth and power laser focused on, suing the government and taking on any efforts to use public authorities in the service of the public good. And so, some of that reluctance was somewhat understandable, but I think it got back to this core issue of, do we have a full understanding of the tools and authorities that are even available? Or are we allowing the kind of, Reagan legacy, where I think when Reagan came in, there were so many different actions they took and efforts they took to not just lay down the arms of the government and retire certain authorities, but also in key ways actually narrow the agency's own understanding of what their purpose was. And we saw this at the FTC, how even something like consumer protection, where the underlying laws use words like not just deception, but unfairness. Right? This is a law against unfair acts or practices. And it was used to take on all sorts of business conduct. And the Reagan folks, when they came in, I think, this is a philosophical shift that's less appreciated than some of the shifts in antitrust. They basically introduced a conception of consumer protection that said the real goal of consumer protection is to make sure that consumers have access to accurate information. And they basically kind of stripped out of unfair and deceptive practices the kind of, moral core of it, and said, no, this is really just about, are there disclaimers? Are people being actively deceived? And what we want to be promoting is instead a kind of, a marketplace where rational actors have access to information and then, in an atomized way can all be making their best decisions to maximize welfare. And I think there are kind of descriptive problems with that in terms of like just a misunderstanding of how people operate in our economy, but also, really undercutting and narrowing with no basis in the law what the original goals and contours of these areas of law is supposed to be. And so I think there was a version of that happened in so many different agencies. And so oftentimes it was less a matter of, public servants saying, hey, we're not going to do our job, and more just a legacy since really the 80s of a real narrowing and thinning out of how these agencies even think of themselves. I think we have seen versions of that across various parts of government. I mean, another core place where we see this is in Congress, where there was a, very active effort in the Gingrich Revolution to undercut congressional capacity, right? There was a real cutting of staff, a real cutting of expertise, in ways that has made Congress much more dependent on outside lobbyists. And so the institutions that we have today are, in many ways a direct result of decisions that were made many decades ago to really undermine and undercut them. And that is what has contributed to this real problem of economic governance and, a real, I think, asymmetry between public power and private power.
Yeah, really like that answer. So I'm looking through these questions that we've been given because there's so many good ones. I think I want to yield to them, and there's one here right near the top that actually overlaps with the question I wanted to ask. It's the question Shabani asks: how do you retain optimism in the judicial system and institutional structures in today's environment where it feels like the rule of law is being ignored? How can we as students and young professionals uphold the rule of law in substantial ways? My version of that question comes from my experience working with the Electronic Frontier Foundation, where we started we were a law firm, right? We were an impact litigation shop. And then we got some activists. And broadly, the activist job was to support the impact litigators, because ultimately that was our leveraged way of approaching the world, that we could make appeals to the Constitution. And as a small group, we could make very large changes in the law and its practice, the conduct of firms, the conduct of the government, and so on. And activists were there to make people understand why it mattered and, get people to write their congressmen to support legislature and so on. And now I kind of feel like in this environment where the rule of law really only materializes when there's enough political pressure to ensure that there are public consequences, not legal consequences, but sort of reputational, electoral, and I get no other word for it but political, right? In the small p, like people are going to be angry at you and the political winds are going to shift, changes, that maybe activism is like the first line of defense. And when activism does the job right and makes the political consequences of, for example, not releasing the Epstein files so intense, then the law gets followed too. So, I mean, you're an expert legal tactician. You're also a great rhetorician and good at like kind of playing the institutions. You can't be looking at this situation that we're in right now and being sanguine about it. Where do you sit? How do you get to sleep through the night when this stuff is going on?
Yeah, I mean, it's a really weighty question and one that's very central right now. I mean, I think big picture, looking closely at history and various historical moments that our country has navigated, including the 20s, the Great Depression. I mean, there was some really dire moments, and, a lot of work that had to be done to then set us up for a New Deal. And I think there's no question that it feels like we're reaching just a real nadir when it comes to our institutions across government really working in a democratic way. There's no doubt that we've seen a real backsliding when it comes to the rule of law, when we see, commitments to core democratic principles. I think you're right that when it comes to the legal system, we have to be mindful that that is a core structure and system for organizing our society and organizing our democracy, but it is not the only one. I think it's been really interesting to see on the ground advocacy on this question of data centers and whether communities have to just surrender to data centers, showing up in their backyard. I think this is an issue that pairs so many of the frustrations that people have right now, one of which is just how much are they paying for stuff? And so it's like, am I going to have this data center come online that's going to jack up how much I'm paying for energy, that's going to, degrade the quality of the water that our families are drinking, and at the end of the day, just aggregate more and more power in the hands of a small number of tech companies who, by the way, are telling us that there's an inevitability around this new technology coming out that's going to take all of our jobs, and maybe after they're enjoying all of their riches, they'll throw us a few pennies, right? And I think the frustration across all of those areas is now coming together in a way that communities are organizing, they're standing up, they're pushing back against some of these data centers, or at least demanding that the terms and conditions on which these data centers are being stood up are ones that where the public has the opportunity to weigh in. And so I definitely think that those types of organizing efforts are going to be especially key. I think in addition to backsliding in the courts, the fact that our key levers for electing representatives have been so overwhelmed by money in politics is a real problem. It goes back to first principles, and there's no doubt in my mind that if there is an opportunity to govern across the federal level, there are going to need to be some first order issues to take care of, which come down to this question of, our constitutional system and these three branches of government can only work if there are certain institutional preconditions that are met. There are institutional preconditions for what has to be true in Congress, for what has to be true in the courts. And unless we fix that, be it, at the level of money and finance, money in politics, at the level of, redistricting and representation, or at the level of, court accountability. The courts, I think, have started to arrogate so much power in the judiciary at the expense of Congress in a way that I think is really inverting the constitutional structure, where Article 1 in the Constitution is Congress, right? The courts are at Article 3. And I think there has been this kind of judicial, juristocracy that has taken hold in a way that has huge negative implications for our democracy. And so I think all of that needs to be fixed. I think in the meantime, looking at what has happened historically when we similarly ran up against real democratic lows, and finding ways outside of the legal system to be organizing seem really key.
Yeah, yeah. I'm looking at the questions here. They're good, and they kind of circle some big themes, and it's hard to pick out the most effective avatars of those themes. But one that I'm interested in, that I think builds on the question you just answered, comes from Conrad. How can legislatures effectively create mandatory rather than permissive enforcement duties to ensure disfavored statutes don't go unenforced based on political priorities, as we've seen in antitrust agencies historically and currently? And, I guess this is the question of, how do you create a rule of law that is backstopped by a political love of the rule of law? Because, of course, you can write anything you want in the law. I mean, this is the point you just made, right? There's a bunch of stuff in the plain language of the statute that's not mays, it's shalls, where the agencies just, sat around doing nothing. I'll tell you from my perspective, as an activist who's worked on a lot of legislative campaigns at state and federal level, pluralizing enforcement, very big. And harnessing enforcement to no win, no fee, private sector plaintiffs bar, also very, very good. Ask anyone who's ever gone up an ADA ramp that was installed not by a lawyer who had any particular love of making sure that buildings were accessible, but did understand that people who have deep pockets and do bad renovations can be used to pay their kids' way through university. There are lots of ways of doing this. I mean, the reason we haven't gotten a new federal privacy law, despite several runs at it in the last several legislatures, is that the poison pill that, or rather the no-go zone, the bright line that the opposition will not tolerate as a private right of action. They want privacy law to be enforced only by the attorney general, because they think that they can suborn the attorney general. And what they definitely don't want is a billboard saying, did some creepy data broker use your data? Call 1-800 sue him, and we will take them to the cleaners, right? So that's my view, is that pluralizing enforcement creates stakeholders for not laws per se, but a given law or legal regime that who will stand up against the watering down of that law, not necessarily out of a commitment to ideology, but out of a commitment to their own bottom line. I don't know what your feelings are on that, Lina.
I think that's absolutely right that broadening who can enforce the law is absolutely essential. We're seeing right now in antitrust alone, the fact that you can have state attorneys general enforce the antitrust laws, including the Clayton Act to, halt illegal mergers is so essential at a moment where so much of the federal apparatus on merger review seems to have descended into total pay for play. Right. And you
Yeah.
have what seem like flagrantly illegal deals just being expedited now, right, rather than even scrutinized. And so the efforts that we've seen from the state AGs to, sue to challenge the Nexstar Tegna merger, the Paramount merger are so essential. Private rights of action are key. And actually, there was a legislative debate when the Sherman Act and the Clayton Act were being crafted around this question of whether there should be a private right of action. And there was a recognition that a world in which monopolies have captured your government and has disabled the enforcement of the antitrust laws, that you really needed an escape hatch and empowering regular people, regular Americans to have their own right to challenge monopolies was a key way to make sure you weren't stuck in some doom loop where you had a monopoly capture the government and then disable antitrust and then monopolies get even more powerful. And so, in antitrust in particular, private rights of action are so key. But I think beyond that, this also gets to this issue of legislative and statutory design. Oftentimes, the way that our laws are designed, especially when it comes to governing corporations, governing economic power, is that the default of non-enforcement is something that is benefiting the powerful actors and harming the non-powerful actors. And you can imagine actually designing statutes in ways so that that default is flipped.
Hmm.
So, in our merger laws, just to give a very concrete example, right now the law is that deals need to be reported and there's a 30-day pause. And unless the government acts, the companies can go ahead and merge. The fact that you even have that 30-day pause is really important, but you could imagine a world in which, you extend it, for example. And so how you are allocating the costs and benefits of law enforcement or the failure to enforce the laws is something that can also, I think, compel more enforcement if it's some of the powerful actors that are best positioned to lobby the government are the ones that are also going to be harmed if they don't do anything.
Yeah, I think you're touching on something great there, which is, the administrability of different policies, which I think is so often out of the room when we talk about, we fantasize about what laws we would pass or what rules we would make or how we would set up an enforcement regime. And I guess this is an area where like science fiction writers, law students, and activists do something that maybe actual working lawyers, unless they're lobbyists, don't do a lot of, which is just think about what law you would make if you could make a law. And I am often struck by the extent to which people design it, regulatory regimes for conduct that happens very frequently that requires intense inquiries into fact.
Mm-hmm.
And so, for example, like everyone who's kind of on the side of rightness and goodness is like, well, we should have a rule against hate speech online or harassment online or other bad conduct, bad speech acts online. And what no one ever seems to engage with is the fact that administering that law would require first agreeing to a definition of these somewhat squishy concepts, then deciding whether a specific act rose to that definition, then holding an inquiry to determine whether or not the firm took adequate steps to prevent that from happening. This is a thing that happens like 100 times a second, and it's going to take you 2 years to solve one of them. Right? It's fine to have fact-intensive inquiries into probate, right? Most of us die one or fewer times, but like fact-intensive inquiries into things that happen 100 times a minute make no sense. So, what if instead we said, okay, everyone just has the affirmative right to like plug new services into old ones. So if you're getting harassed there, you can go somewhere else, but still stay in touch with the people who left you behind. It'd still be nice if we could make the companies prevent harassment on their platforms, but we don't make people wait until we've adjudicated these fact-intensive questions before they can get relief from these awful circumstances.
Right, right. And I think even things like once the complaint is made, is the platform have any incentive to clean it up, right? Rather than
Mhm.
drag out the litigation or the adjudication. I mean, one thing that we saw in government firsthand was just how many levers these actors have to drag out the litigation as long as possible. Just even taking on monopolization can take over 5 years between, filing the case, getting the verdict, getting the remedy. And so especially in fast moving markets, that could just be too late. I mean, I think the other thing that your point brings to mind is, in what instances are we just stuck cleaning up the downstream harms from what are actually really harmful business models? And in what instances should we really be taking on the business models themselves, or setting certain clear structural rules or others, rather than just be stuck doing cleanup with all the downstream natural results of these business models or conflicts of interest? And so I would say that would be, in addition to how do you design the legislation, at what layer are you actually targeting the intervention is another key question that can help.
Yeah, that's a very systems thinking way of approaching it. There's a joke from Eastern Canada whose punchline is, "If you wanted to get there, I wouldn't start from here." I often think about the place that we're at now and how much harder it is to solve so many of our problems because it's gotten to this point. It would have been nice to see a labor movement among tech workers back when tech workers were in short supply and weren't being laid off by the hundreds of thousands, when they had all kinds of juice with their employers and their employers were terrified about them quitting. Of course, now that there's a glut of tech workers, they really need those unions, and this is the hardest time to start them. So I want to move on to Maud's question, but before I do, you've raised something there that I just want to ask you if you have off the top some examples, which is what are some good bright line tests? Right? Like, I like the idea of interoperability because it's a bright line test.
Yeah.
Can I leave Twitter, go to Blue Sky, and still see the messages on Twitter? Is a question that has you can solve in a minute. You can't drag that out, right? You just find out whether it's true or not. When I search Amazon for a specific product, is the first result that product or someone who paid to put their product, which might be inferior there? A thing you can determine in 1 second, right? So are there bright line tests that you think, when you put on your law professor, sim regulator, or real regulator hat, that you're like, okay, there's a bright line test that we could administer?
I mean, I think generally structural separations, or things that limit, if you own this or if you're playing in this sandbox, you can't also play in that. Those are policies and policy principles that have a long history in our economy, going back all the way to the railroads, where the railroads at that time were buying up coal mines and buying up kind of commodity shops, and then they would transport their own coal, but not those of independents. But even in banking, we have the separation between banking and commerce, the idea being that banks are such critical intermediaries of the credit supply that you don't want their lending decisions to be corrupted by considerations for what it would mean for their own commercial enterprise, right? In telecom, as you well know, right, we had the FinCEN rules. We've had instances where we've separated out distribution of content from production of content. And right now, across our economy, we see an area after area of vertical integration. And sometimes, look, vertical integration can be benign. It can be, even have certain benefits. But I think especially in instances where you have vertical integration by entities that themselves have become gatekeepers of a type of commerce, or in a very consolidated market, that's where you can see all sorts of conflicts of interest. You can try to police those conflicts and say, well, you can't do this or you can do that. But as you referenced, administrability here is core. And so oftentimes just a cleaner solution is a structural separation, saying if you're in this business, you can't also be there. I think another clear bright line rule is often just bans on certain types of activity. So when we were at the FTC, we were scrutinizing non-compete clauses. There's been a lot of economic literature showing how these non-compete clauses really undermine workers, undermine their wages, also have negative implications for entrepreneurship, for innovation, for new business formation. And as we were thinking about, what intervention to take, there were a lot of different ways to potentially structure a rule. And historically, government has often been interested in disclosure-based regimes to say, okay, companies can still have non-competes, but they have to include them 2 weeks in advance before the employee has to sign the contract, and in font size 14. And, I think at the end of the day, we decided that a ban would be more administrable, and B, that the overall benefits from the clarity of a ban would something that would override, any harms from it. So I think just more clarity at the level of bans. Small businesses actually are often the ones that most want those type of bright line interventions, and it's actually big businesses. And we saw this during Dodd-Frank, where it was the big banks that were all for as complex a regulatory scheme as possible because they would have all the lawyers they could hire to
Sure.
navigate it, as opposed to oftentimes small entities that really want just like, tell me the rules. I don't want to have to hire outside lawyers. I just want to know how to follow this.
Yeah, when you got a building full of lawyers, everything looks like a compliance moat. So Maud McCall says, to what extent can antitrust enforcement solve issues of economic justice, especially given the entrenchment of efficiency as a legal standard and the prevalence of consumer welfare? What other tools do we need to look into areas like ad tech where competition might increase harms? I will say, because I raised the ad tech example, that I think to build on what you just said, there's a remedy for ad tech, which is to just make commercial surveillance illegal. And the reason we can't make commercial surveillance illegal is because we have market concentration and firms are sloshing cash, and there's so few of them that they're able to arrive at a common lobbying posture. And so every time we try to make a privacy law, it fails. I think probably law students might know this. We haven't had a new federal consumer privacy law in America since Ronald Reagan made it illegal for your video rentals to be released, right? Everything else is legal. That's why we have a privacy problem. And it's not like it's hard to write a privacy law. Like, no one's asking anyone to recover the lost praxis of a fallen civilization, right? Congress doesn't need to embalm a pharaoh. They just need to write a law of the sort they wrote every decade or so for a century. I'd be interested in your views on what we need beyond antitrust.
Yeah,
To
I mean,
answer
look, I
Maud's
think
question
antitrust
there.
is a key tool, but it is not the entirety of the toolbox. And antitrust really stands for certain principles of fair competition, both when it comes to market structure, but also when it comes to how firms can act or not act. But there are going to be all sorts of markets where competition is not the governing principle that makes sense. In our economy today and in our legal regime, it is often the default principle. But historically, there were sectors where we recognize there's going to be, a tendency to monopoly or certain benefits to concentration that instead we want to apply more of a public utility toolkit. And there was actually also a legal tradition around, what are now being called network platforms and utilities that encompassed, how we regulate the railroads, to how we regulate banks, to how we regulate telecom. And, sometimes this used to be called regulated industry. Sometimes it used to be called infrastructure law. And it was actually a class you could take in law school, where you would learn not just about just one sector, but the kind of coherent way to think about all of these different sectors that have more utility or network type properties. And people like Stephen Breyer really cut their teeth on this area of law. One thing that happened after we started deregulating in the 70s and 80s was that this area of law disappeared. And so, nowadays you can usually take a class on banking law or a standalone class on telecom law, but there isn't a unified class that's thinking about all these different areas of law through the same prism and through the same principles. I think honestly, that is one reason why our response legally to big tech was kind of stunted, because I think in prior decades, you would have seen some of these fact patterns and said, hey, we have a toolkit for that. When you have these overarching gatekeepers, what are the common carriage or interoperability or other principles that we've applied? That's changing. Some of my colleagues, including Lev Manan, Ganesh Sitaraman, Morgan Rick, Shelley Walton, have written a new casebook called Networks, Platforms, and Utilities that is
Cool.
going through all these different areas of law and providing a coherent approach. But outside of that, there are areas where it's going to make sense to allow atomized entities to come together. And so think about labor law, think about areas where we have co-ops. So I think there are different models of kind of economic organization, and competition is one of them, but certainly not the whole deal. I think outside of that, and one thing that I'm really hoping the center can help with is I think there's no doubt over the last few years, there's been a ton of attention on antitrust and the evolution of antitrust from this kind of core vehicle for liberty and democratic markets to instead, oftentimes facilitating monopolization. There have been similar moves in all sorts of areas of law. And so, think about intellectual property, think about how we do tax, think about how we do banking law. There are all sorts of areas of the law that need the same type of attention that we've seen towards antitrust in terms of understanding the roots, understanding how these areas of law have often been warped and what it looks like to really return them to their original principles in ways that can contribute to creating an economy where, that's really serving working people. So yeah, I think there's more within anti-monopoly in terms of tools beyond competition, but broadening the aperture even more outside of that, all these other areas of law that are really ripe for intensive study and that I hope more people will take on.
Yeah, a fun fact that I learned from reading Matt Stoller's book, Goliath. The reason they broke up AT&T in 1982, but not IBM, is that Reagan's ideologues were like, well, we can probably sell breaking up AT&T because it was a regulated industry. So we're not actually intervening in the market. We're removing a market intervention. Whereas IBM is, a product of the free market, and the fact that it's had its boot on the throat of the American tech sector for 50 years is neither here nor there. And luckily, just the process was such a punishment that IBM cleaned up its act anyway. Serafina, computer science doctoral candidate, interested in cases and literature on algorithmic collusion and pricing, and wants to know about what parallels there might be in the labor market and harms workers' experience. She cites antitrust guidelines for business activities affecting workers from January 2025, which points out that there are anti-competitive concerns from companies sharing sensitive wage information, but there are more and more third-party sites publishing salary benchmarks that are using AI to recommend which benchmarks firms should use. And the justification for this is pay equality, which is a good thing. So how do you square the circle between data sharing as a way of finding out whether there are structural inequities in pay schedules versus data sharing as a way to secretly collude to rig wages, or not so secretly collude to rig wages because everyone shares their data and then you all follow a benchmark that's recommended by an AI whose training is opaque and whose management is opaque and whose prompt is opaque, and then everyone somehow magically ends up with a lower wage, but it can't be because of anything bad, because math is not racist. So it just must be because that is the true wage everyone should have.
Yeah, it's a very timely question and certainly something that is coming up more and more. Obviously, it's always a very fact-intensive exercise to figure out, is there actually collusion happening? Is there not? And under the law, there are various tests and indicators that you look at in terms of how competitively salient is this information. You look at things like, how granular is it? And so are you going, in terms of what these companies are publishing, is it an average across their entire workforce or, by product description? Or is it really going position by position and detailing what is the specific salary? How timely is it, right? Is it kind of looking back at what the salaries were a few years ago, or is it kind of more real time? And so those are some of the types of factors that end up being relevant under the law. I think it's absolutely true that companies are very astute in terms of thinking about pro-competitive justifications, especially if they can sound in things like pay equality or pay transparency. And the question then becomes, okay, but is there a less anti-competitive way you could have done that? And I think one of the real trends that we're seeing now, and there are cases being litigated on the consumer side, is these middlemen that go around basically, collecting competitively significant information, be it from a variety of meat packers, be it from a variety of landlords, and then take in all that data and then kind of spit out, various other data that are recommended rents or kind of recommended, payments that are teeing up this question of, is that collusion, or is that a form of price fixing, essentially? There are a whole bunch of cases being litigated right now, and honestly, this is one area where sometimes courts are getting it right, but sometimes, unfortunately, they're getting it wrong. And so more research, more scholarship, more amicus briefs to make sure that courts are not creating a, algorithm exception to price fixing is going to be really key.
Sorry, I hit my mute there. I'm always reminded here. There's a wonderful Croatian activist named Marko Rakar, whose life motto is "May the way of others be lit by the bridges I burned behind me." And Marko, he became very famous for looking up the service records of people claiming veterans benefits in Croatia, and finding all the people who never fought who are claiming veterans benefits, and particularly people in government, and sometimes who are claiming veterans benefits 10 or 15 times over, and faced, like being hunted by death squads and whatnot. And Marko, during the IRS leaks event, emailed me and was like, we just publish everyone's tax returns here. Like, everyone's tax returns are just public, right? So, like, that is one way we could resolve the question of inequitable wages, right? There are other countries that manage to have stable governments that just tell you how much everyone else earns. I mean, I have to say, there's parts of me that are not entirely comfortable with that, but it's like, it's certainly like not, asking for water that's not wet, right? It's entirely possible. So I want to move on to some career advice here for law students. There's two questions I wanted to combine. One's from an anonymous attendee who asked about early career suggestions for a rising 3L who's interested in helping workers feeling depressed about the state of the and future of labor and labor law. I'm wondering what other areas of law you think could be used in creative ways to help workers, pathways for combining antitrust and labor in a career. And then there was another question somewhere here. Let me just see if I can find it. There were so many questions now that it's hard to sort through them. That was, I think I'm just going to paraphrase it because I can't locate it here. It was basically, what do we do about the fact that everyone who graduates from law school with a crushing amount of student debt ends up getting recruited into big law and just like working for the enemy for at least 5 years and maybe longer if they end up losing their soul while they're at it? I know that's not exactly how they phrased it, but that's how I'd phrase it.
Yeah, both very practical questions. I mean, on the labor and antitrust front, I think this is a great area of potential synthesis. And, there are a lot of great labor organizations that do traditional labor law litigation, but have now been thinking more about the antitrust dimensions, especially as we're seeing some of these technological ways to screw workers, be it in terms of kind of, surveillance wages or some of this algorithmic wage fixing. State AGs are a really great place these days to be doing some of this work. There's a ton of interest. Oftentimes the challenge for AGs is that they're very small offices, but there are places like California and New York, Chicago that have, pretty well-sized offices, and especially these days where they're having to step into the federal void, there's just a huge demand for this work, and so that can be one place where you're able to kind of push through on both fronts. The big law challenge is a real one. I think sometimes it is a challenge of students even having access to those opportunities, and so a lot of law schools have, a very well-oiled machine when it comes to big law recruitment in terms of the specific, days of the year where all those big law firms come to campus, and a very organized way for people to sign up for interviews. But the same types of opportunities for the government or for plaintiffs' firms are just not structured in such an organized way for people to know, kind of to be handed those opportunities on a plate, and there requires just more hustle. I hope that's starting to change more and more across schools, but this is also something that I'm hoping the center will be able to help support students on in terms of identifying opportunities that can exist both in the plaintiff's bar as well as across government, as well as some nonprofit organizations. I think the financial issues are real ones. Law school is very, very, very expensive, and a lot of people leave law school, with debt, oftentimes with also responsibilities to support their families. And so, how any given person juggles and weighs those considerations can be very complex. Um, More and more law schools increasingly are offering public interest fellowships or public interest forgiveness programs, where if you agree to go into some type of public interest program after law school, there can be opportunities to not have to pay some of that debt back. Forgiveness programs. Beyond that, I think even for people who find themselves in big law, be it for financial considerations or because, as right now, opportunities at the federal level are so limited, I think there can be important steps to take to make sure that, 15 years on, you're like, the last thing I went to law school to become a big law lawyer, but now I'm here and I feel stuck. I think there are important ways to stay plugged into other communities and communities that are doing the type of work that you want. To the extent that you live in New York or other cities, making sure you're engaging with events that are happening, be it book talks, be it events that are happening in universities, to stay plugged into those communities of interest, and constantly be thinking about, if in 2 years or 3 years, what would that off ramp look like? I think that can help avoid a situation where you feel just stuck and unable to figure out how to leave. Um, of course, there can be certain times where other opportunities are more likely to appear. So, for example, anytime the House or Senate flips, the party that will be coming into the majority is going to be expanding in staff. So I worked for the House Judiciary Committee starting in 2019, and I was hired because that was when the House flipped from Republican to Democrat. And so now that the Democrats were going to be running the House Judiciary Committee, they were looking to staff up. And the committees in particular are where a lot of hiring happens. Same happens at the Senate level. And so kind of thinking about, Januaries where the House or Senate are flipping as opportunities. Of course, if there's a new president coming in, those can be key times. And unfortunately, the reality of the legal field in particular is that A, it is very hierarchical, and B, a lot of the hiring decisions really do function off of networking oftentimes and who you know. And so again, kind of taking the time before you even want a job to be kind of getting to know who are the key people in some of these fields, and what can I do to kind of be in community with them. I also think that especially in some of these areas of the law that have a lot of that are kind of viewed as somewhat arcane, there can be a lot of just good work that people can do through their scholarship and through their research. I think a big comparative advantage that people can have is just learning a lot about how something works. And especially in parts of the economy that seem really murky and really arcane, sometimes that complexity is by necessity. Sometimes that complexity is designed to deliberately be opaque and kind of keep the public in the dark about what's really going on. And so somebody who spends a lot of time really understanding the mechanics of how a pharmacy benefit manager works, or the mechanics of how contracting in the chicken farming industry works. This is really important knowledge. And somebody who has that information is going to be so valuable to teams, especially in the government, that are looking to hire. And so I think building up deep expertise in a particular sector, in a particular market, again, especially where there is a lot of opacity, can be really key, and also help kind of jumpstart your ability to jump into public service. I think similarly, spending time doing research in different areas of the law, reading organic statutes, actually reading the law beginning to end. One thing that our team did when we got to the FTC was read the FTC Act. And there were a bunch of provisions that we were like, that sounds interesting, and would ask our general counsel, when was the last time we used this? And the answer was not for many decades, if ever. And so thinking about, do we have a full grasp of what the laws actually say? I would say those are two ways that you can do substantive work to also hopefully make it easier to jump into a public interest or public service job.
So it's very good advice for aspiring photocopier kickers. I would say also on the question of labor and antitrust, read Alvaro Bedoya, uh, or Alvaro, I beg pardon, who's Lina's former colleague at the commission, particularly a speech he wrote called "Aiming at Dollars, Not Men," which is a quote from I think it was LaGuardia, and there's an antitrust law LaGuardia wrote that was like, for avoidance of doubt, in words so small even a federal judge can understand them, we did not mean antitrust law to say you can't have a union. Please stop ruling that that's what antitrust law means. And the phrase he used, we're aiming at dollars, not men. So I want to close out because we're basically out of time here. But Benwan Malau asks to know more about your political appointment and makes a point of adding that New York City is the most economically important city in America, which you love to see that in there. Then that's why your question got asked. So Lina, what are you going to do now that you're in charge of the most economically important city in America?
Yeah, it's exciting. So this week I was announced as chairing the board of directors at the Economic Development Corporation in New York City. So this is the agency charged with economic development in the city. I'm on the board of directors, so it's not the day-to-day management, and I'm still going to be running the center and teaching at Columbia. But I think there is a lot of opportunity. And I think, the mayor has made affordability a central plank of his agenda. And so thinking about how we can do development in a way that is advancing affordability, but also how it is building and investing in state capacity. Oftentimes the default model of economic development in New York, but in a lot of places, has been public-private partnerships where you're using public financing to spur private investment, but oftentimes that can come at the expense of investing in the public capacity itself. And so really going back to first principles and thinking about, where does it make sense to be using that private-public partnership versus where can the state be doing more, or should we be working with the private sector on terms that are more favorable to the public and making sure we're getting more bang for our buck? Those are the types of questions. But for those with some time this summer, we welcome ideas. If there are specific ideas and proposals and policies that you think EDC should be pursuing, very much welcome it. This mayor has also made a core part of his tenure making sure the public is engaged across government and making sure government is really listening and learning from the public rather than just kind of narrow circles of experts. So I'm excited about that work ahead. And I think it's going to hopefully contribute to the broadening beyond antitrust and consumer protection and making sure we're looking across the economic policy toolkit, because we're going to need a lot of these different levers to help get to a better economy.
Well, that was fantastic. We are at time here, but Zachary has asked me to leave you a minute at the end for your prerogative to make any announcements you have.
Yes.
Before we sign off.
Two things I'll mention. One is thanks so much to everybody for coming. We're going to be doing a regular cadence of these types of virtual fireside chats with a whole bunch of experts that we have at the center and others. So stay tuned for that. The other is we're going to be soon announcing publicly an opportunity to submit scholarship and work for awards. And so stay tuned on that. Recipients of the awards will be have an opportunity to come to our annual conference. And so more on that front. But the goal is to help spur and recognize good scholarship in antitrust, but other areas of the law. And so we'll be sending out information on both of those fronts soon.
Fantastic. Well, it's been a real honor. I didn't realize this was the first of these that you were doing, so I'm very pleased to be your inaugural interlocutor here. The program seems amazing. I'm so excited to see you move from being such an inspirational figure on the national and domestic stage to also having this direct mentorship role. I know a little of your own past and how you benefited from mentorships from key people. I certainly have as well. And creating a pipeline of people who are excited about these issues and kind of equipped to go forth into the world, such a force multiplier. So I am very pleased to watch you assemble your botnet and can't wait to see what you do with it.
Thanks so much, Cory, and thanks so much, everybody.